The truth has struck a nerve. I'm Jessica Denson, and this is Lights On. I'm going to be really blunt with you right now. We are in a battle over who is willing and honest about the action that is needed to be taken in this moment, the constitutional guardrails that our founding documents outline for us to prevent ourselves from descending into dictatorship, and others who are not willing to do the work and want to present an alternative set of information to you that would discourage the action that is so vitally needed right now, and in the process engage in a smear campaign to try to discredit some of our nation's greatest preeminent constitutional scholars and scholars on the 14th Amendment. So you are going to get more clarity today on Lights On, as you have been getting. As you know, I have had numerous lawyers, although the smear campaign against this show has tried to claim that non-lawyers are making this argument. Last week, we had constitutional scholar and author of the original meaning of the 14th Amendment. I, of course, have interviewed Crew President Noah Bookbinder and preeminent constitutional scholar Lawrence Tribe, who have confirmed that Donald Trump is, in fact, a enduring disqualified insurrectionist after the ruling in Trump v. Anderson. We are going to continue that conversation today with yet another scholar on the Constitution. His name is John Bonifaz. He is the president of Free Speech for People and co-founder of this organization, which does invaluable work for our Constitution and the rule of law and democracy. He's also the co-author with former law professor, now Congressman Jamie Raskin, of 2 seminal law review articles, and he knows as well as anyone the enduring power and force of Section 3, as do preeminent scholars William Bowd and Michael Paulson, who have made crystal clear that if action is not taken in accordance with that article of the Constitution, that it is not because it is what the Constitution requires, neither is it because it is what Trump v. Anderson requires. So, as you know on Lights On, I am laser focused on not engaging in the mythical, fantastical thinking that we can mitigate our problems once a constitutionally disqualified individual with zero allegiance to the Constitution passes the Rubicon into the presidency. All bets are off at that point, and it is time right now in this moment to take every action, as difficult, uncomfortable, and unprecedented as it may be, to stop us from descending into dictatorship. That is what is incumbent on us in this moment. So I take any attacks on my reporting as an attack on our prospects to save our own republic for the survival of the free world. That is literally how serious this is, as pompous people on out-of-touch networks try to tell you other things to keep their profit model going. So forgive, or maybe don't forgive. I will make no apologies for my lack of patience for this nonsense. And please join me. Please join me in welcoming my esteemed guest today, John Bonifaz. John, welcome to Lights On.
No, that's all right, Jessica. I'm right with you. I appreciate you speaking truth to power on these critical questions, and thank you for having me on.
Okay. Now, as you know, my reporting over the past couple of weeks has come under basically a hit job from, I will name them, the Meidastouch network this past weekend. And I shared a few of these videos with you just for clarification purposes. Before we delve into some specific questions I have for you, would you address just your thoughts off the bat on the information that is being put out there to their 3-point-something million subscribers?
Well, I think it's critically important to understand that there were unresolved questions coming out of the Trump v. Anderson ruling of the U.S. Supreme Court. And anyone, whether they be from another network or from a law school or wherever they may be, who claims that these questions are resolved and that there is no issue whatsoever to be discussed after Trump v. Anderson, is frankly just not speaking the truth. And I think that's really what the issue here is now. I'm not going to claim, like they seem to do, that they have an absolute hold on what the Supreme Court will do if there is further congressional action or a challenge to the county electoral college votes on January 6th. I'm not going to claim that the Supreme Court will do X or Y. We have no idea. But others who want to make those claims really are pretty much blowing smoke.
Well put. Well put. One article that you and I think, share in our great appreciation for a Harvard Law Review piece is Sweeping Section 3 Under the Rug. This, of course, is written by preeminent scholars William Bowd and Michael Paulson. They wrote this in the wake of Trump v. Anderson. I have cited this numerous times. And basically, it comes to the conclusion that should constitutional actors decide to sweep Section 3 under the rug for generations, it is not what the Constitution requires, let alone what Trump v. Anderson requires. As you mentioned, they call Trump v. Anderson a judicial train wreck. And I think that's actually one point that we can all agree on. I know over the past weekend, it has been persistently portrayed as a 9-0 unanimous decision, when it actually is more of like a 5-4 or even like a 5-3-1 decision. Because the per curiam was the decision that made all these allusions to congressional action without explicit directive was not shared by all 9 justices. Amy Coney Barrett wrote her own, and the 3 liberal justices wrote their own, specifically talking about how all of this enforcement language was unnecessary. But even getting to that enforcement language that suggests that Section 5 of the Constitution requires somehow that new legislation be brought. Is there or is there not explicit directive in Trump v. Anderson that the only path forward is for new legislation on Section 3?
There's no such explicit statement of that from the per curiam decision. And that is the decision that, as you cite, was the 5 justices, 2 of whom, frankly, needed to have recused themselves, Justice Thomas and Alito, for their clear bias and conflict of interest, having demonstrated their support for the insurrection. In the case of Justice Thomas, through his wife being actively engaged in trying to overturn the 2020 election. And in the case of Justice Alito, allowing flags to be flown outside his homes, supporting the insurrection. So both of those justices had no business being on this case. And the whole decision is under that cloud of corruption that they were part of that ruling. But those 5 made no explicit statement whatsoever in their ruling that there needed to be enforcement legislation enacted by Congress. And then we go even further, and we know that Mark Joseph Stern at Slate discovered through, frankly, some rushed effort in terms of publishing this opinion, that the 3 justices on the so-called concurring side, led by Sotomayor, were actually writing a dissent initially. They were not writing a concurring opinion. So, there is a clear unresolved question out of this Supreme Court as to how this Section 3 of the 14th Amendment is to be enforced. It was not articulated whatsoever by the per curiam decision. All that per curiam decision said was states do not have the power to enforce Section 3 of the 14th Amendment when it comes to federal officers. They invented out of whole cloth an exception for candidates running for federal office. Now, that in and of itself is a nonsensical ruling. And clearly, we know that if you're 12 years old and you're running for president of the United States, states have the power to exclude you from the ballot under a separate part of the Constitution that disqualifies anyone who is not of 35 years of age by the time they're taking the oath of office. And furthermore, if they're not a citizen, a natural born citizen of the United States, states have the power and have executed that power to bar people from running for president. Even then, Judge Gorsuch of the 10th Circuit upheld that particular ruling coming out of a Colorado decision. So there was no basis for the Supreme Court to invent this exception for Section 3 of the 14th Amendment, saying that it now only applies when it comes to state offices for states to enforce it, but not to federal offices. But there was also no language in that per curiam opinion that said there needed to be enforcement legislation enacted by Congress, or frankly, any guidance whatsoever as to how Section 3 would be enforced at the federal level, which is why it now leaves open the door for a member of Congress to present on January 6th an objection to the counting of electoral college votes for Donald Trump on the grounds that he was ineligible to have been on those ballots and to have run for president.
It absolutely does. I want to speak, as I have been on this show, about the practical routes forward. And before I do, I want to share with the audience a piece that you sent to me. This is an editorial from the New York Times just last week by Jamel Bowie. It is called "Now is Not the Time for Surrender." Let me read just the first couple of paragraphs. Democrats may be in the minority, but they are not yet in opposition. What's the difference? An opposition would use every opportunity it had to demonstrate its resolute stance against the incoming administration. It would do everything in its power to try to seize the public's attention and make hay of the president-elect's efforts to put lawlessness at the center of American government. I could go on. This article, I will note, does not make any mention of specifically Section 3 or Section 3 enforcement, but that sentiment I think you were pointing to, John, is exactly what we need, not foreclosing options that are not even foreclosed to us in advance, but availing ourselves of every single possibility before all bets are off.
Absolutely. And look, we have to remember, right, that leading up to this election in November, we were told repeatedly that Donald Trump is a fascist, that he's a threat to our democracy, a threat to our republic, all of which I believe is true. But that didn't change after this election. He remains a fascist. He remains a threat to our democracy and our republic. So this idea that now, because the election has occurred, we are no longer going to raise these arguments, we are no longer going to resist this threat to our democracy is frankly incredible. I'm shocked that we have seen such silence from so many who were making these arguments, literally leading right up to the hours of participating in the process on November 5th and beyond. So, that has to be front and center right now. There is no change with respect to Donald Trump. He has been an insurrectionist from the moment he incited that insurrection on January 6, 2021. He was found to be an insurrectionist and disqualified by 3 separate states: in Colorado by the Colorado Supreme Court, in Maine by the Secretary of State, and in Illinois in a case that we brought at Free Speech for People by a judge in Illinois. 3 different jurisdictions found him to be disqualified. Not one jurisdiction that looked at the merits of this question found otherwise. Those were the only 3 that dealt with this to the merits, and all 3 found him to be disqualified. So he was adjudicated as an insurrectionist. The Supreme Court didn't touch the merits of those rulings whatsoever, and he remained an insurrectionist on November 5th, and he remains an insurrectionist today. And the fact is that he remains disqualified today, and that's what that article about Ian Paulson wrote. That's what we have said, and many other scholars have said. And it's now time, really, for those who have that ability to raise these objections to do so on January 6th. There's no reason why they should not. Some people will say, well, do they have the majority votes, which it would take, of course, to an objection to be supported? That's really not the question right now. The question is, should an objection be raised? Should someone stand up in that body, and put forward this motion? They're going to need to have, under the new Electoral College or Electoral Count Reform Act, they're going to need to have 87 votes in the House and 27 votes in the Senate to lodge it. But someone ought to step forward to start that process.
Yes, absolutely. As you just mentioned, it's a 1/5 requirement to raise the objection and a majority threshold to confirm it. You're the second constitutional scholar. Last week, we had constitutional law professor Evan Burnett confirm that to us, not a sports law professor, but an actual constitutional law professor. And I thank you for confirming those facts. I don't think, John, we can put too fine a point on the onus that is on Democrats. You mentioned how clear they were in the past about Donald Trump being an insurrectionist. We could also discuss at length the January 6th committee's work and all of the clarity that was brought forward in those hearings. We could discuss at length the speeches that they gave on the floor of the Senate in the morning hours of January 7th, 2021, the complete lack of ambiguity on this man's complete unfitness for office for inciting a deadly insurrection. And I really want to hit home this point. If this democracy falls, if we pass the Rubicon and go into this autocratic oligarchy that we are headed towards, and so many things become irreversible, possibly for generations, which is bound to happen by this man and his allies who have made no pretense about their intentions. The blood of this democracy will not be on the Republicans and MAGA who we already know. We know their colors. We know who they are, and we've called them out. It will be on the Democrats, on the pro-democracy individuals, on the so-called pro-democracy media trying to shepherd the masses who drop the ball in this moment. It is up to them to not let democracy die on our watch, is it not?
No question. And look, there are 70 plus million people in this country who did not want to see this threat to our democracy come back into power, did not want to see this insurrectionist come back into power. And those tens of millions of people deserve representation. They deserve to see resistance to this threat to our republic. And that starts with raising the very point that remains open today, which is Section 3 of the 14th Amendment has made very clear via these three different state adjudications that Donald Trump is disqualified. He does not have the ability to be back in public office. That's why we have Section 3 of the 14th Amendment. It's designed to preserve our republic. That's why those who framed that 14th Amendment did so after the Civil War. And, the idea that we're just going to ignore it now, because there was an election that somehow swept away Section 3 of the 14th Amendment, it makes no sense. It makes absolutely no sense. The duty of those in Congress who take that same oath of office that Donald Trump took in January of 2017, that duty requires them to stand up and protect and defend the Constitution. And now more than ever, that duty calls.
Absolutely. And I want to touch on that. Even taking the election results at face value, and there's many of Americans who have rightful concerns that we did not do our election hygiene in this election. And that is another shame, but in discussion we won't bring here. But taking election results at face value, I just want to address, and again, this is a conversation I fleshed out in countless interviews on the Meidastouch network, which, by the way, I was the one that brought the disqualification conversation to the Meidastouch network with the lawyers from Crew and Professor Tribe, which they failed to inform their viewers of. But I had these conversations with them countless times about how, when Section 3 was drafted, it took into account that an insurrection may be elected by a majority, not to mention the actual percentage of eligible voters we're dealing with that actually voted for Trump in this election, if the numbers are right, is about 33%. So it's a small number. It's not a majority by a stretch. But even if an insurrectionist is elected by a majority, that Section 3 of the 14th Amendment is a constitutional backstop to safeguard our republic from someone who has zero allegiance to upholding it.
Yes. And in fact, if you think about the qualifications that are in the Constitution to be president of the United States, this is probably the most important, right? I mean, you could imagine a 25-year-old who somehow is allowed to be on the ballots in every state, wins the electoral college vote, wins the popular vote, and we'd be having a conversation about how that qualification is being ignored and the Constitution is being ignored with that person coming into the Oval Office. But there's plenty of 25-year-olds, frankly, who I don't think will be a threat to our democracy. This particular provision is designed to protect the republic when someone has taken an oath of office and then engaged in insurrection, precisely because they will very likely do it again if they're back in office. And that's why the framers of the 14th Amendment were intent after the Civil War in not allowing those who had incited that first insurrection in our nation's history, the Civil War, and had been in the Confederacy, to come back into power. So that's why we have that provision in the Constitution. It's designed to protect the republic. But even if, this was about a 25-year-old, we would need to be saying the same thing. Either we accept that we have a constitution that's the supreme law of the land, or we do not. And if we accept it, that constitution is what needs to be followed, then it needs to be followed in all instances, whether it's an age qualification, a natural born citizenship qualifications, or this qualification of Section 3 of the 14th Amendment.
Okay, John, before I let you go, I have to have you once again with me be redundant on this issue of the 2/3 requirement to remove the disability. The Out of Touch network I've been referencing continuously is telling their viewers that a 2/3 vote of Congress is required to make Donald Trump an insurrectionist. Here is Section 3 in front of us. It says Congress may, by a vote of 2/3 of each house, remove such a disability. Can you clarify this? Is this logic being or non-logic being proposed not in fact the direct opposite of the requirement of Section 3?
It is not a statement, frankly, that is credible coming from anyone who claims to have a knowledge of the Constitution and being a constitutional lawyer. So I don't think these statements are frankly coming from people who are constitutional scholars or lawyers, but any plain reading of that text and any scholarship of the 14th Amendment makes clear that the purpose of that language in Section 3 of the 14th Amendment was to allow Congress to provide amnesty for people who were already disqualified, having been engaged in the insurrection after the Civil War, but also applied to any future insurrection. So it allows Congress to vote 2/3 to provide amnesty. So if Congress were today to go ahead and pass an amnesty bill for Donald Trump, they would need 2/3 of the vote of the House and the Senate to do that. And then that would wipe the slate clean for Donald Trump. That amnesty bill would take precedence over the rulings from Colorado, from Maine, and Illinois. But we don't have that amnesty bill pending in Congress. There has been no effort to provide an amnesty, and he's not even sought that amnesty, which is what a lot of Confederates sought after the Civil War, and in some cases won. But the inverse is not true. 2/3 is not required to find him disqualified. It's solely required to provide him amnesty. What's only required to provide him disqualified, frankly, is a majority vote on an objection to the votes being regularly given with respect to electoral college accounting on January 6th. That's what would be required. And, look, I understand some of your listeners might say, well, where's that majority vote going to happen from? That I'm not really going to focus on that right now. That's not the point. The point is, can we at least have some courageous members of Congress to stand up and defend the Constitution for history's sake, for the sake of broadening the narrative here that somehow we're going to ignore the Constitution because an election occurred. That's really what this is about. And let's let the chips fall where they may. If a majority vote is not there, then every member of Congress who voted against the Constitution will have them on record.
On record.
That's how they vote.
And by the way, John, if it goes back to this compromised Supreme Court, they will be on the record too. Put them on the record. Put
Correct.
everybody on the record as to where they stood in this moment. And like you said, let the chips fall where they may after we do the right thing.
Correct. Absolutely. That's what it's about. It's about standing up for our Constitution, our democracy at this critical moment in our history.
Absolutely. John, I want to thank you so much for joining me today. I was so grateful that I thought of your wonderful organization, Free Speech for People, this weekend, and that you were so willing to just jump into this conversation about Section 3 and give us the clarity that is so desperately, desperately needed right now.
Thank you, Jessica. It's an honor to be on your show.
Thank you so much. And thank you everybody for joining me here on Lights On. I came into this fight against Trump lawlessness going on 7 years ago under my motto for myself was silence is not an option. I brought a lawsuit without a lawyer, pro se, 2 lawsuits against the Trump campaign that people like Michael Popak and Ben Meiselas, lawyers with so-called gravitas and years of experience, told me was never possible and never going to succeed. I've been dealing with jealous and doubting men for a long time. And I fight back not for my personal reputation, although if you come at my personal reputation, let this serve as a warning that I will not be restrained in my legal response to you. But I fight back, as I did then and as I do now, because you're not just coming for me, you're literally coming for the survival of our republic right now. And as long as I have a platform, which, by the way, I am not a wannabe lawyer. If I wanted to be a lawyer, I'd be one of the damn best, but I don't even want to be a lawyer. All I want to do is be a citizen who is not lying down as our democracy dies on our watch. And I will make no excuses for clarifying lies and misinformation that people trying to do damage control because their audience is sick of the misleading grifting that they're doing, are trying to put out in the atmosphere. So I want to thank everybody so much for your commitment to democracy. I want you to stay tuned to Lights On, because here on Lights On, like I said, if the lights went off on a podcast tomorrow and we saved our democracy, I could care less. That is my only objective. But I'm going to ask you to stay tuned right now, because I'm focused on action points. I want you to please follow John's suggestion. Put the pressure on the Democratic members of Congress in this moment to do their jobs, to not let the stain of the blood of democracy be on them, for them not to go down in history with a chain of steel, as Adam Schiff said in that impeachment trial, and to do the right thing. I'm going to be giving you more action points as I get them and as I have them to share, so I will be sharing them here. Most important thing you can do for the purpose of sharing this message is to subscribe to my YouTube channel, Jessica Denson, and share this video. I'm going to put links to my previous interviews with other scholars, with other directives for bringing that amnesty bill. I think we are frankly running out of time for that. The time right now, I think, is just to put as much pressure as possible on these congressmen and congresswomen to do their jobs on January 6th. So I will put the links in this description. If I have I will put specific phone numbers, scripts, anything that you can use to exert your peaceful pressure as a citizen who loves this country on those members of Congress who have an oaths to uphold. Thank you so much, everyone, for being part of this. Stay in the fight, and for God's sakes, let your light shine.